Good morning. As stated, I am Nicholas Cummings. I'm here in my capacity as the president of the Cook County Bar Association. It is the oldest association of black lawyers and judges in the country. As Robin mentioned, I'm the former corporation counsel for the city of Evanston, so it is good to be back in the community that I once served for approximately 3 years. It's also good to see the progress that has been made in the program that we worked so hard together on. So my presentation today deals with the law and its impact on Black Illinoisans. As Robin mentioned, the presentation is done by Osiris. Osiris is a consulting firm that I founded after I left Evanston, sort of at the behest of Robin, to be able to help other organizations that actually want to do this work. So repair and restoration is important. The legal framework that we built in Evanston is repeatable. I evangelize it every opportunity I get. I thank the commission for the opportunity to talk about something else other than Evanston, though, but I'm sure I will weave it into this presentation. So we're going to talk about how the law has and continues to oppress Black folks here in Illinois. And again, I am the founder of Osiris Professional Services, former corporation counsel for the city of Evanston, who's the first municipality to actually use municipal tax dollars to provide repair and restoration in this country. So we're going to break down our talk today into four eras: the Reconstruction era, Civil Rights era, the War on Drugs, and present day. So Reconstruction era, the Illinois Constitution, as written in 1870, explicitly prohibited slavery except as punishment for a crime. It would take 100 years before the Illinois Constitution was amended to include an equal protection clause, guaranteeing that no person could be denied equal protection under the law. In 1874, Illinois passed a law prohibiting segregation in public facilities such as hotels, restaurants, and railroad cars. However, enforcement was problematic. The laws on the books were rarely enforced by law enforcement officials, which was key to part of the legal framework, which I'll keep touching on later. But the lack of enforcement or the lack of ability to correct these wrongs to the rights of Black folks is a key linchpin in order to try and provide repair and restoration in this work. Illinois enacted its own Civil Rights Act in 1885. It was modeled after the Federal Civil Rights Act in 1875, which ultimately was ruled unconstitutional by the Supreme Court of the United States. Interestingly enough, the Supreme Court determined that the 14th Amendment only prohibited discrimination by the state and its local subdivisions, and therefore Congress lacked the authority to regulate private discrimination. The Illinois Act of 1885 was introduced by John W.E. Thomas, Illinois' first Black state legislator. In an act of an attempt for reparative and restorative justice, this act fined $25 to $500 for each violation, with the money going directly to the aggrieved party. Again, enforcement was problematic, with only fines being levied and law enforcement mostly looking like the offending party. You can imagine how likely the law was to be enforced. Moving on to restrictive covenants, touched on briefly by Robin. The famed case of Shelley versus Kramer was the result of a split in the state court systems. The Supreme Court of Missouri reversed the judgment of a state trial court denying enforcement of a private agreement restricting the use or occupancy of certain real estate to persons of the Caucasian race. Meanwhile, the Supreme Court of Michigan affirmed a judgment of a state trial court enjoining violation of a private agreement restricting the use or occupancy of certain real estate to persons of the Caucasian race. In this instance, there was no state statute, there was no law. These were private agreements that were enforced by the courts. In granting judicial enforcement of the covenants, the states denied the petitioners the equal protection of the law in violation of the 14th Amendment. And that is why the Supreme Court ruled that these covenants were illegal. But again, you see that the government was acting, even though there was no statute on the books, the government was acting and enforcing these in violation of the rights of Black folks. Moving on to the National Housing Act of 1934, which created the Federal Housing Administration, which institutionalized redlining. Redlining was a private practice, but the FHA essentially institutionalized it. The Homeowners Loan Corporation created maps that categorized neighborhoods by risk, heavily influenced by racial composition. These maps were used by lenders and insurers to deny loans to Black people. And unlike the Civil Rights Act of 1885, Illinois did not have any legislation to counteract these discriminatory practices. The lack of anti-discrimination laws allowed the practices of restrictive covenants and redlining to thrive. In this instance, the state was what we call under the law deliberately indifferent to the rights of Black people. I'm going to take a moment to briefly describe the theory of deliberate indifference. It's something I picked up when I was an assistant state's attorney defending civil rights cases. The theory of deliberate indifference is when the state or an agency is aware or should be aware of a violation of someone's rights and fails to act. So that failure to act now creates liability under civil rights law. And that is part of the linchpin of how we were able to create restorative justice and repair in Evanston. Between 1919 and 1969, the city of Evanston lacked any sort of enforcement authority to stop racial discrimination in the area of housing. And as a result, the city was deliberately indifferent to this practice for the people who were being denied loans, people who had their houses moved, people who were unable to secure housing as a result of racial restrictive covenants. That deliberate indifference is what we believe is key. Moving on to the civil rights era. The civil rights era saw new legislation meant to try and bring equality to Black people in Illinois. While these laws outlawed discrimination and increased enforcement, they did nothing to elevate or restore Black folk to places they would have been but for prior discrimination, which is actually the entire point here of our reparations and restorative justice work. The Illinois Fair Employment Practices Act of 1961 was one of the first state laws in the U.S. to prohibit employment discrimination based on race, color, religion, national origin, or ancestry. The Illinois Civil Rights Act of 1964, modeled after the Federal Civil Rights Act of 1964, prohibited discrimination in public accommodations, employment, and housing. It created the Illinois Department of Human Rights, and the Federal Voting Rights Act of 1965 made prior practices of voter suppression illegal, and the Illinois Human Rights Act of 1979 was more comprehensive and strengthened protections against discrimination. In 2020, it was amended to prohibit denial of employment based on a positive test for cannabinoids. So we have some progress here, right? But then, of course, taking two steps back, we enter the war on drugs. Many states around the country enacted laws imposing harsh sentences on drug users and sellers, and Illinois was no different. Illinois' Controlled Substances Act makes possession of certain drugs like cocaine, heroin, and methamphetamines with intent to deliver a Class X felony. For those of you who don't know, Class X is Illinois' highest level of felony, okay? Class X felony in Illinois will get you 6 to 30 years in prison. There were also mandatory minimum sentences for certain drug offenses, particularly those like cocaine or heroin. Manufacturing or delivering 15 to 100 grams of heroin will get you a minimum of 4 years in prison. There were also repeat offender enhancements, which they're used today for gun offenses, but have also been used for drug offenses. The Habitual Criminal Act can lead to a life sentence for those with 3 or more felonies, depending on the nature of felonies. Now, enforcement of these laws were not targeted to those manufacturing or importing drugs. Rather, addicts and dealers alike were prosecuted under the same laws, and I know this as a former assistant state's attorney in Cook County who actually clerked in the narcotics division in bond court. And you would see dealers and users alike being paraded in to see a judge to set their bond. In 1991, the U.S. Supreme Court case Harmelian versus Michigan held a criminal sentence is generally constitutional if a state has a reasonable basis for believing that the sentence will further any of the 4 main purposes of punishment: deterrence, retribution, rehabilitation, or incapacitation. The Eighth Amendment does not require strict proportionality between the crime and the sentence, forbidding only a sentence that is grossly disproportionate to a crime. Thus, a first-time offender who may only wanted to try drugs for the first time being charged with a Class X felony here in Illinois is possible and completely constitutional. Black folks, of course, were arrested at higher rates and sentenced at harsher penalties. As a former assistant ASA, I can tell you that a 3-time drunk driver under Illinois law is potentially a felon, but a first-time drug offender is an absolute felon. The war on drugs had substantial impact on our communities, including loss of employment opportunities, housing discrimination, family disruption, and weakened social structures and networks. As we know, Black people, despite similar rates of drug use, are more likely to be arrested and receive harsher sentences. For example, mandatory minimum sentencing for possession of crack cocaine was harsher than the possession of pure cocaine by a ratio of 100 to 1. The marked increase in arrests and sentencing leads to criminal records that are at times prohibitive to obtaining gainful employment. This has negative economic consequences in the Black community, creating cycles of poverty and creating economic instability. Recidivism becomes an issue. A lack of access to gainful employment forces some back into a life where the only access to capital they have is criminal activity. Until recent changes to fair housing rules and regulations, having a felony conviction presented obstacles to obtain housing as well. In a little bit of irony, the most difficult housing to obtain for any convicted felon is public housing. In addition to those economic consequences, there are social consequences as well. These higher rates of incarceration disrupt Black families. Children of incarcerated parents face emotional and economic hardships. Speaking broadly, the reduced number of Black men in our communities created weakened social networks. The quintessential story of the streets raised me, especially our Black boys, who find solace in male companionships and other avenues that are not necessarily legal. In the war on drugs, the casualties in the Black community are much higher than the successes in reducing drug trafficking. Even now in 2024, the United States continues its war on drugs, with the current administration using the threat of tariffs to get countries that share our borders to increase efforts to reduce the amount of fentanyl in the United States. Now, I'm not here to offer commentary on whether the war on drugs was actually a war on Black people, but I can tell you that the laws that seemed racially neutral on their face were enforced in a way that certainly made it seem that the targets of the war were Black people. Moving on to the present day. There has been a lot of activity in Springfield. I know we have our state legislators here, commission is here, but 2020 was a flashpoint marking the next era in advancements in civil rights for Black people following the murders of Michael Brown, Laquan McDonald, and George Floyd. Illinois in particular has made several changes to try and balance the scales. In 2020, the recreational use of marijuana was legalized in Illinois, and that tax was instrumental in starting the fund in Evanston for reparations. Convictions of those convicted under the aforementioned statutes, if they were convicted for possession of marijuana, they were expunged. And the act has also made certain cannabis-related offenses automatically expungable. The Safety Act made changes to drug sentencing laws, eliminated cash bail, and allows for police discretion to write a citation for individuals in possession of less than 15 grams of certain controlled substances, which in the past was a Class 4 felony, right? So we are the Class X, Class 4, Class 3, Class 2, Class 1 are the levels of felony in Illinois, and so Class 4 being the lowest, you were automatic felon in possession of drugs, even under 15 grams. But now the Safety Act has allowed police officers the discretion to write tickets for that. House Bill 4123 amends the Unified Code of Corrections to change the calculation of time served for certain offenses. For example, murderers are required to do 75% of their time rather than 100%. Class X drug offenders are no longer restricted to sentence credits that they receive, whereas previously they were restricted to 7.5 days per month. Now, I know that seems very dense, so I'm gonna try to break it down best I can. If you are arrested in Cook County and you are in jail you are held in detention awaiting trial, there are days you get credit for in terms of your sentence. That time that you served in county jail counts towards your sentence time, right? That didn't happen for Class X felons. They were only allowed to receive a certain portion of that credit that they spent in county jail and had to do more of their time in state prison. Now, of course, and this as I was preparing for this presentation, I realized that California, in fighting the wildfires, were using incarcerated labor. So I had to figure out if Illinois is one of those states that uses incarcerated labor. Illinois still maintains a law related to incarcerated labor. 730 ILCS 5/3-12-2 requires that the Department of Corrections provide workers for Illinois correctional industries to work in programs established to train and employ committed persons in the production of foodstuffs and finished goods and any articles, materials, or supplies for resale to state agencies and authorized purchasers. So though Illinois does not lease inmates to private entities like the states of Alabama, California, Florida, Georgia, Texas, Arizona, Mississippi, and Louisiana, all these warm weather states, right? Workers are only provided in Illinois for state-run industries. I don't know what all those state-run industries are, but I do find that to be interesting that our incarcerated inmates, they're leased to the state to do work for the state, to provide goods for the state, to be purchased by the state. The legacy of enslavement and servitude laws, coupled with the 13th Amendment's punishment clause, continues to impact Black communities through modern policing and criminal justice system. The use of prison labor and the disenfranchisement of felons are key issues that perpetuate systematic inequalities. Illinois, while not leasing inmates to private companies, still grapples with these challenges, particularly in this criminal justice system. We see consequences of the war on drugs continuing on our communities, further perpetuated by housing segregation and implemented earlier still. We are fortunate here in Illinois in terms of the disenfranchisement of felons. I believe Illinois allows you to at least come back and get the right to vote after you've completed your sentence. There are several states where I think there's 11 states that once you are convicted, you never get the right to vote back. Or at least it's very difficult, as in Florida, you can get the right to vote back, but you have to pay your restitution and all these other fines that you still might owe in order to get your right to vote. I believe we used to call that a poll tax back in the day. So understand that the law has not always been the friend of Black people in this state. But it is getting better. So I don't want my friends in the legislature to look at me with ire when I say that our hard work is being demoralized here. That's not true. I understand that there's been some advancements, but understand we still have a lot more work to do. And thank you for your time.